And today is Monday, November 24th, 2025. This is Section 1 of Admiralty Law, and we are going to be introducing the so-called Robbins Dry Dock Rule, which is part of Module 15. Earlier today, I discussed the other part, which is Rule B attachment, which is completely unrelated. The only thing they have in common is they're both little oddities of Admiralty Law. So what is the Robbins Dry Dock Rule? Well, before we talk about the case Robbins Dry Dock, which is where it supposedly originated, let's explain what the rule is. The rule is another one of those filters. And by filter, I mean things that courts use to keep cases and plaintiffs out. The first one we discussed, I forget what the module number was, but we talked about the idea of proximate cause and how if you're too far down the chain of causation, you're going to be excluded from the number of plaintiffs who can get in a lawsuit. So we used the example of the bridge being hit, and the bridge owners, sure, they can sue. Proximate cause, it clearly, the vessel hitting the bridge caused their loss, no doubt about it, both factually and legally. The people who faulted their deaths, sure. Then we got into those hypotheticals, somebody who couldn't cross and lost a contract, and his daughter who couldn't do the piano lessons because, the contract had been lost. Those are the excluded ones, right? Well, Robbins Dry Dock Rule makes it even easier in maritime cases. If it's a maritime negligence action, the only way you can be a plaintiff and seek to recover is if there was physical damage to property that you own. Not property that you charter or lease or anything like that, not economic losses without physical damage, not other harm to property you own that doesn't include physical damage, and we're going to talk about that in a minute, but physical damage to property that you own. What about personal injury? Well, for purposes of the Robbins Dry Dock Rule, that is not a consideration. If your body is hurt, it's the same as physical damage to property that you own, as if your body is your own property, which is a reasonable way to look at it. So don't worry about the personal injury component. That doesn't even really get analyzed under Robbins Dry Dock Rule. But what does get analyzed are situations like this. I'm going to tell you about the case that I had that I tried to take up to the Supreme Court, and I'll tell you the facts of that case. My client, American Petroleum and Transport, owned a tug and a barge. They were going up Eastchester Creek and loading the barge, which was a tanker barge that was going to carry petroleum products, and American Petroleum was going to load it up there, go back out, and deliver it to clients, to pump it on board vessels, whatever. There's a drawbridge on the way up. Eastchester Creek is the same as the Hutchinson River, just two different names. And there's a drawbridge on the way up that has to go up for maritime traffic to get through. When it's down, the cars go across it on the Hutchinson River Parkway. When it's up, the cars have to stop and the vessel goes through. So on the way in, the bridge opened up nicely, and the barge, tug and barge went up there and loaded the fuel. And later in the day, they got underway and came down Hutchinson River, or Eastchester Creek, and signaled to the drawbridge operators that they needed to be open. The drawbridge operator said, nope, sorry, broken now, you can't get out. So for 3 days they sat there. Now the drawbridge is 100 years old. It was 100 years old at the time, and that was like 10 years ago. I forget the exact numbers, but it's an old bridge. And it's not particularly well maintained by the city. And the city, actually under federal law, has an obligation to maintain drawbridges. All owners of drawbridges have an obligation to maintain them under federal law. But the city of New York does what the city of New York wants, and often doesn't do what is necessary to make everything work right. I'm not afraid to say that on video. We all know that. So what happened? Well, the city doesn't mind if the drawbridge stays down, because then the vehicular traffic moves fine. And that's really what people complain about most. The occasional maritime traffic, they get stuck up in the river. Too bad, so sad. So my client had a tug and barge up there for 3 days, had to pay his crew, could not deliver, could not make the profits that he lost doing, that transfer of petroleum products, and suffered relatively small damages. I won't say minuscule, but trivial by the perspective of most of these cases. It was like $30,000. So it wasn't huge. But I filed a notice of claim against the city, and of course they did nothing. And I also filed a federal lawsuit, and then they did something. And actually, the first thing they did is they had good corporation counsel. And they wrote me a letter, said, please withdraw. Under Robbins Dry Dock's rule, you can't recover. And I knew that they were right, at least in some parts of the country, under what the circuits there had said. The Fifth Circuit clearly would have agreed with them. It was a little iffy on whether or not the Southern District of New York would agree with that. So I proceeded with the case, and motions were made, and the city made a motion to dismiss, and they won. Southern District of New York Judge Paul Engelmeyer wrote a very thorough opinion, but found for the city, saying that the Robbins Dry Dock rule prevented recovery. So again, what is the Robbins Dry Dock rule as it's applied? It says that to recover, you have to recover for negligence in a maritime case, you have to own property that is physically harmed. So in this case, my client owned the property. He owned the tug and the barge. Nothing was chartered, it was owned. So that part was fulfilled, but was there physical damage? Well, no, they were physically trapped up there, which is pretty analogous to physical damage. And I suppose if they had said, if you can't open the drawbridge, we're just going to keep coming, and then there would have been physical damage, but then they would have said you caused the damage yourself. But bottom line is, they were physically trapped up there, and they certainly had proximate cause as to their damages, right? But for, first of all, they had, but for causation. But for the drawbridge not being able to open, they would have gone on their merry way with their cargo and delivered it, and everything would have been fine. And they certainly were the first in the chain of causation. The drawbridge was supposed to open just for them, and it didn't. So there's no long chain of causation where proximate cause becomes an issue. Clearly, there's proximate cause. So the only thing keeping them recovering is this Robbins Dry Dock rule. Now, where did that come from, and does it make sense, and why did I challenge it? Well, the case, Robbins Dry Dock, is from 1927, and it doesn't really create the rule we're talking about. And I'm going to go over the facts and outcome of the case real quick. It was a very short opinion written by Justice Oliver Wendell Holmes, Jr., who's written some pretty bad opinions in his day. Look up Buck v. Bell one of these days. 3 generations of imbeciles are enough, authorizing mandatory sterilization. That was an Oliver Wendell Holmes case. But this one wasn't quite as egregiously horrible, allowing involuntary sterilization of people against their will. This one just doesn't allow somebody to recover. And in this case, it wasn't so unreasonable. What happened in Robbins Dry Dock? Well, Robbins Dry Dock obviously is a ship repair facility, a dry dock. And there was a vessel in there, and it was getting fixed up. And the charterers of the vessel, I think it was called Flint and Company, they were waiting for it to come out of the yard, and it was going to go into operation. It was crucial that they get it on time. They had a good deal. Market rates were changing, so they weren't going to get a deal like what they had, and they really were going to lose money if that ship didn't come out of the dry dock on time. And everything was going great, except that Robbins Dry Dock made a big mistake, and when they were putting the propeller on the ship, they dropped the propeller. It dropped, from, here's the ship in dry dock, and the shaft is, maybe, 50 feet off the concrete flooring, and they're putting it on, and oops, boom, and this brass propeller now isn't shaped like a propeller anymore. It's got this big bend in it, and it's not going to work very well with the big bend in it. Propellers are kind of engineered to be a certain curvature, and anything deviating from that, it's not going to propel very well. So the ship was delayed considerably in coming out of the dry dock. So Flint, the charterers of that vessel, sued Robbins Dry Dock for their negligence that caused them the economic harm that resulted from the delay in the vessel coming out of the yard. And so basically, Oliver Wendell Holmes Jr. said, the law does not spread its protection that far. That's the exact quote. In other words, you're not the owner of the vessel. The damage to the propeller was not damage to your property. And this economic harm, yes, you may have suffered it, but the law isn't going to protect you. It's just too far removed. Didn't use proximate causation. He may have been thinking in those terms. It's hard to say what the thought was, but since it was the Supreme Court of the United States, it became a rule that under those circumstances, where it's a charterer suing for economic harm, where there's damage to property, physical damage to property that it doesn't own, it can't recover. Now here, we're not talking about that. We're talking about an owner of property where there's no physical damage and it has economic harm. For some reason, along the line, some of the lower federal courts decided to extend the holding from Robbins Dry Dock, the original case, to a bigger rule. And why did they do that? Well, they did that for the very reasons we talked about in the beginning, to limit the number of plaintiffs who can sue. And the big case was a big mass casualty down in the Gulf region, I believe it was in the Mississippi, a vessel called the MV Test Bank. And that case went to the Fifth Circuit en banc, meaning every judge in the Fifth Circuit weighed in on it. And they decided they were going to limit the number of plaintiffs to only those that had suffered physical damage. Because it was one of those, vessel hits a bridge and down the line, it's all that sort of thing. But rather than relying on proximate cause, they based their decision on the Robbins Dry Dock case. And they decided to fashion a new rule, which is the rule that I had to deal with, that said, if you're, unless you own property that is physically damaged, you can't recover for pure economic harm. Okay? So there were many plaintiffs in that test bank case that were excluded because the court wanted to limit it. But here's the thing, when that went en banc, when all those judges of the Fifth Circuit ruled on it, the decision came down about 60-40. So just a bare majority of those judges said we should apply this rule. The dissents all said, no, it's ridiculous. Robbins Dry Dock didn't say that. Okay. So when I had this case, that case had already been established. That case goes back to the 70s. This case occurred in the 21st century. The Southern District decided to apply this rule, and I challenged that and went to the Second Circuit. At that point, the Second Circuit had some prior case law that indicated they might, in fact, go the other way, the way the dissent in the Fifth Circuit had gone, and not apply this rule. There was a case called Kinsman Transit where the Second Circuit had kind of indicated a likelihood not to apply that rule. So I thought I had a pretty good chance. Well, I had 3 judges, and they decided I didn't have a pretty good chance. They affirmed the decision below, wrote an opinion, and the rest is history. I petitioned the Supreme Court for review, and they denied cert. So the Second Circuit then joined the Fifth Circuit in saying that this rule applies, and the Supreme Court declined to take the case. Now, question. Why should the Supreme Court grant cert in a case like this over almost any other kind of question of law? Why in maritime law would the Supreme Court of the United States have a greater obligation to rectify this problem? Where did this law or this rule come from? Did Congress make up this rule? Who made up the rule? The courts, right? The federal courts. Admiralty law is largely judge-made law. And this Robbins Dry Dock rule is a classic case. It started with the case of Robbins Dry Dock, Oliver Wendell Holmes, 1927. Then lower courts building on that case, particularly the Test Bank case, which is also known as GUST, G-U-S-T-E, Inri Gust or MV Test Bank. One is the name of the party, one is the name of the vessel, same case. It's a Fifth Circuit case from the 70s. They expanded what Robbins Dry Dock said to create this new rule, very succinctly saying that unless you own property that's physically damaged, you can't recover for negligence under maritime law. Period. So it did a lot more than the Robbins Dry Dock case, but it created this bright line rule to keep plaintiffs out. Now the Fifth Circuit did that, and then the Second Circuit joined them. And I went to the Supreme Court saying, fix it. It's your case that started the problem. This is entirely judge-made law. Congress is out of it. You have an obligation to fix it. Did they fix it? No. Am I pissed off about that? Yes, because they do have an obligation. They created the mess. In fact, in other cases that I cited, they clearly said, we have never endorsed this bright line rule that the lower courts have made. Okay, well now's your chance to decide if you want to endorse it or not. But no, they didn't. Why not? I don't know. The problem with petitions for cert to the Supreme Court is they probably fall through the cracks. They're reviewed by law clerks. Unless they get a bunch of amicus briefs in support and everybody's spending hundreds of thousands of dollars to get there, they get missed. So it's very possible that not one of the Supreme Court justices was ever even aware that this case was there in the offing. I have no idea. When they deny cert, they don't say, we're denying cert because blah, blah, blah. They just say cert denied. So that's what happened in this case. I have an excerpt from my petition for cert as optional reading in the Module 15 materials. But this is the Robbins Dry Dock rule and I like to say the so-called Robbins Dry Dock rule because it doesn't directly come from Robbins Dry Dock. But the rule, just to wrap it up, is that in a maritime negligence action, a plaintiff cannot recover unless they are the owner of property that suffered physical harm. That's it. So my client, as owner of a tug and barge that were physically trapped by a drawbridge that was negligently maintained by a city that had an obligation under federal law to maintain that drawbridge, a separate statute, still can't recover. And every judge in this case, Judge Engelmeyer in the Southern District, Judge Newman in the Second Circuit who wrote the opinion, they said, we know that the Robbins Dry Dock case didn't create this rule, but we're going to use it anyway. If you want relief, go to Congress or the Supreme Court. Well, I didn't go to Congress, because that would have been an even bigger waste of time, but I did go to the Supreme Court. And where did it get me? It got me the opportunity to sit here, I was going to say stand here, before 4 live people and an audience of an unknown number out there in cyberspace and complain. And on that note, Thanksgiving is coming up. Be thankful for whatever justice you get.